Now, I know I'm going to Snopes, and I'm going to tell you, I'm prepared to accept their conclusion here. Let's see. Did Trump's lawyers forget to check a box requesting a trial jury? On October 2nd, 2023, former President Donald Trump appeared in person to witness the proceedings in a case brought by the New York City attorney Letitia James against his business empire. James accused Trump's businesses and business associates of persistent and repeated business fraud. The case, notably, is a bench trial in which a single judge, Arthur F. Engoron, the one we dissected yesterday with his 8-year-old speech, not only controls the proceedings, but ultimately rules on the facts of the case as well. In a makeshift press conference held during a break in the first day of the proceedings, Trump says, "I think it's very unfair. I don't have a jury." Legal experts and pundits immediately questioned the claim on the basis that, generally speaking, anyone in New York State is given a right to a trial by jury as opposed to a bench trial. And then we just saw that. Okay. In response to Trump's complaint, Engoron later stated that, in fact, nobody asked for a jury trial. The Messenger and other outlets initially argued that neglecting to file a simple form with a checkbox was the reason for Trump's lack of a jury trial. Okay. Sorry, let me just see one thing here. Okay. Earlier this year, Letitia James filed a form with a check mark next to the field trial without a jury. Trump's legal team didn't file a corresponding form, and the president may have regretted his lawyers' inaction ever since. Letitia James had requested a bench trial in a form filed publicly in June 2023. That notified defendants of their readiness for trial. Almost anyone can demand a trial within 15 days of such a notification. As a result of the imagery of a check mark on the court-issued notice of the seemingly clear right for anyone to demand a jury trial, a talking point emerged to the effect that Trump's lawyers forgetting to check the box was the sole reason for a lack of jury. Okay. In an interview with Newsmax, Trump lawyer Alina Habba made the argument that her team, in fact, never had a right to a trial jury in the first place. And this is the lawyer saying, "I have to address this one common misconception in the press, and unfortunately it just keeps getting repeated, which is that we have this great option to have a box checked for a jury. No, we didn't. That's not how it works. They brought it under Section 6312, which is a very narrow, not appropriately used section of the law, which is for consumer protections, not this. And that is why we're sitting here in front of the judge." This is according to Snopes, for those of you who are listening on podcast. 6312 refers to a section of New York state law that allows an attorney to bring an action against businesses or people that engage in persistent repetitive fraud. Yeah. David Schoen, a lawyer on Trump's impeachment team, who was not part of the fraud case, cited a 2011 case in which a judge from the same court said there is no right to a jury trial under New York Executive Law 6312 in an interview with CNN's Poppy Harlow. The statement about the case is not entirely correct. There is no written law that Snopes can identify explicitly mandating bench trials under 6312, but there is a legal precedent for a jury trial being denied to a case brought under that stemming from that case. Let's read that again. There is no written law that Snopes can identify explicitly mandating bench trials for those consumer protection cases, but there is a legal precedent for a jury trial being denied to a case brought under that law stemming from that case. The precedent stems not from 6312 cases, but from legally defined exemptions to a right for a trial jury in New York. This is getting very interesting. The specific distinction applies to cases in which the damages awarded are equitable in nature, such as remedies. Such remedies are ones in which the court compels the defendant to perform a certain action or refrain from a certain act. My goodness, the New York laws of, civil procedure laws and rules explicitly states that, that might not be what CPLR stands for, explicitly states that equitable defenses and equitable counterclaims shall be tried by the court without a jury. Several courts in New York have ruled that there is no constitutional right to a jury. Let's just go all the way down here. Oh, hold on, we're all the way at the bottom. In the 2011 case cited by Trump's attorney, Schoen, the judge ruled that remedies sought by James in this proceedings were equitable in nature and that as a result, they did not come with a constitutional right to a trial by jury in New York State. As a result, there exists a firm legal argument that this case was never eligible for a jury trial in the first place. It's almost like the judge has the tools that he needs to avoid even getting to a jury trial, so that he doesn't even have to, judgment notwithstanding a verdict. As Schoen noted, however, there was no reason why the Trump legal team could not have at least attempted to do so, as First American Corporation did in their failed appeal for the jury trial. No. Such an argument, Schoen said, might have been raised regarding the $250 million in financial restitution sought by James. I would have filed a jury demand to litigate the issue because here there are very severe monetary punishments at issue potentially. And I think there's a strong argument to be made for the right to a jury trial. And then we're just going to end it while a substantial sum, the $250 million penalty, is still a form of equitable relief as described by James in her initial complaint. That relief, known as disgorgement, requires, quote, a party who profits from illegal or wrongful acts to give up any profits they made as a result of those illegal or wrongful conduct. Oh. It is true, as Judge Engeron stated, that Trump team did not try to assert a right to a jury trial under the New York Rules of Procedure. It is also true, however, that being awarded a jury trial would have been much more complicated than simply checking a box. It's fascinating, actually. The strong legal arguments. All right, so there's procedure, there's tools that the judge can hang his hat on to deny Trump a trial by jury. Not as simple as having forgotten to check the box, and I would have said, in my mind, it seems implausible that that would have been the sole and only or even determinative reason, because there's an expression in French, what is it? La procédure est supposée être la maîtresse et non la servante de la loi. Procedure is supposed to be the servant and not the master of the law. And so some procedural omission should not violate a fundamental rule of justice. And if you have forgotten to check a box, they're not going to deny you a jury trial. But it's even more interesting to understand the tools that they used between Letitia James and the judge to ensure that Trump doesn't even get a jury trial in this case. Now they got a summary judgment. No, we don't even have to determine those facts. Wow.